Good afternoon, everyone.
Good afternoon.
For the next 10 minutes, we'll be discussing two different cases of two different companies. So, without any further delay, we directly move into the cases.
Okay.
So, in first cases, I'll be playing the role of a lawyer who will be defending our two clients,
And I'll be playing the CEO
okay,
of
CEO
SO Burgers.
Okay,
Yeah.
so let's straightly go into the cases. So, Mr. CEO, just tell me in brief about your company and the main issue is currently facing.
My company is SO Burgers, and we specialize in hamburgers,
Okay.
especially.
Okay.
We serve around 2 countries in the world: Australia
Okay.
and New Zealand.
Okay, that's okay. So, what was the issue?
Issue like we recently went into some kind of promotional campaign, and we promised that a guy owning 50 tokens
Okay.
of our company product will get a car. We
Okay.
will honor him with a car
Okay, so how do they get the coupon?
by buying the product of company.
So it means that the customer have to eat the burger to get the token.
Not really. Any products. We just specialize
Oh.
in hamburgers, but
So
we got different
just,
kind of products.
not just
yeah,
burger,
variety.
any other product of
Yeah,
your company.
yeah. Everything was going fine, but at the last we came to find out that
Yeah?
a coupon was misprinted. It was
Okay.
void. A guy owning the ticket coupon.
Actually, there were not just a guy. There were two guys
Yeah,
who won the
two. Yeah, I
you know,
think two. Mora and
won the competition.
Yeah.
and you didn't provide them car. What was that?
Because the token was void. It was misprinted. So according to our company law, anything that is misprinted, we cannot provide anything, sir. That's
Okay.
our company rule.
So now I got your case, and from my clients, I came to know that you didn't give them the car after winning the competition. So that brings me to show you some of the rules and laws that will bound you to provide car to my clients. So here are some of the rules that I would like to just mention.
It was void.
Yeah, that was void. That your point, but as a lawyer, as a defendant, I have to just remind of you the laws. So look, the first one, I have got the book. Yeah, you can see here it. Okay, the Australian Competition and Consumer Act 2010 comes into this practice. Section 44 of this act says that you have to provide the car to the customers because you just promised that, and anything that hinders in accessing the declared services that were not given to cars is a false promotion. So it's strictly a false promotion according to this law. You should know that.
Because the token was void, sir. Because the token was void. That's what I'm trying to tell you all the time. Token was void.
Yeah, you have to say that because you are the CEO of the company, but we can't accept that because we can see the law. There's another law which will tell you that this is not a void. This was not misprinted. Look, Misrepresentation Act 1972. It also tells that you falsely presented the statement or information that lead to the issue. Okay, so in order to simplify, I can give you some of the example of the same cases.
Did it really happen before?
Yeah, it happened. Like the same case. Like in 2015, it was happened between Australian Competition Consumer Commission and Kogan Australia. It almost the same case happened, and the victim was provided with the remedies. So you have to do the same because you have to provide a car to two of my clients. You can't deny that. Okay.
Yeah, let's see. I respect the law of the country. Let's see what law.
We have to respect, and you have to give the
I'm
car
not paying for void tokens. I'm not giving for void tokens. I will not give car to any of a customer because the tokens were void.
Yeah.
So none of them are getting.
You can't deny that. You have to give car to at least one customer, the one who actually ate and paid for the services. We are not asking for the another customer who ate but didn't pay for the services, but for at least for one customer. And I should remind you that by eating those hamburgers, he got ill. So you have to fulfill your promises and give car to
let's say
my clients. Okay,
let's see.
let's see.
Moving into the next case, I'll be acting as a lawyer,
And I'll be acting on behalf of the company, the shareholders.
so what was the issue?
Okay, with Zoetronics, we were operating in Australia. So at the beginning, we were doing good business in our locality. But due to the competition, due to the increase in competitors, we could not do well in business in recent years.
Okay.
So we were having that problem, and one of our directors, the first director, known as Felix, he decided to relocate the office into new location, Parramatta. So he did not consult about this with us, and he did not say anything of this. And just before moving into the new location, he just said us like, we were moving, so guys, you need to agree with me. And you know, we saw the excitement on the Felix, and then we just without.
So you guys were miscommunicated.
Like, yeah, it was kind of miscommunications. You know, he did not pass the information to us, and you know, he did not look at any of the data or facts.
And you should have.
Yeah, we just regret that. Yeah, we should have. And then finally we moved into the new locations, and there also we suffer loss.
Okay.
So now we are suffering loss. So we came to seek help from you. So why don't you just give us some solutions?
Okay. See, looking at your case, your case comes under like Corporation Act 2001.
Okay.
See, but we got two section.
Okay, under the Corporation Act.
Yeah, we got like 180 bracket 2 of Corporation Act.
Okay,
and 588G
okay
of Corporation Act
So
2001.
What does 180G tells?
So 180 bracket 2 Company Act 2001 tells that the directors of the company can take a decision for a company, but in good faith, good manner, no bad intention, no personal interest, just for the company, acting as a company, not a person.
So you're saying that just Felix could take decision on his own?
Nah, it's not that kind of, but he can take the decision, but he should be indulged with his staffs, with the shareholders before making a decision.
So he should share his views and thoughts with the other shareholders as well.
Yeah.
So what the other one said?
588G. This act, this section says that a director he can take a decision. It doesn't comes under the same case. It's like when a company is facing a high debt in that situation, kind of something devastating situation. This act, this section comes under.
So what does this section says?
See, we got some similar case like yours before. It was like Colesmill versus Mears case. In that case, the director, he was saying that I'm not responsible for any loss of the company on the behalf of shareholders. There was some miscommunication from shareholders and company went into loss, and director was saying nah, because I wasn't consulted, so I won't be responsible. But however, he went to the court, but the judge gave a judgment that everyone is equally responsible. No one can escape because it's a company.
You are saying the same thing will be applicable in our case. It means that we all of three will be equally responsible for the losses.
See, looking at another case, it was like Percival versus Wade. There was no responsible. Director was not responsible. But however, looking on the both case, both scenario, both application, I can say that you three partners, you will be equally responsible. As I'm not judge to decide, I'm just lawyer. I'm explaining law to you. You three guys may be equally responsible for the loss of a company. That's the rule. That's the law.
That will be bad for two of us because we, didn't take any data.
Yeah,
That's our mistake. Thank you, by the way, for your consult.
Thank you very much.
Yeah.